Yes, Mr. Bloch.
Lord, I appear with Ms. Vowles on behalf of the appellant, whom I will refer to as Getty, and then the friends Mr. Saunders KC and Mr. Edwards appear on behalf of the respondents, to whom I shall refer as Stability. Getty owns and operates image libraries, which include millions of images which are available on Getty websites, bearing a Getty watermark in the form of a Getty trademark. Stability has developed a synthetic image model called diffusion, which generates pseudo-images in response to text and image prompts input by users. The way in which diffusion was developed and how it works are the subject to much factual and expert evidence in the current trial. I'm not appearing in that trial. I shall endeavour to avoid saying more about it than I have to, and I anticipate I shouldn't need to say anything which is controversial. Whatever else may be in dispute, it appears to be common ground that the diffusion model was developed with the aid of a data set of images scraped off the internet, a data set which included a large number of images scraped off Getty websites bearing a watermark in the form of a Getty trademark. The claims in this action fall into two categories. First, there are claims based on the infringement of Getty's intellectual property rights in the course of the development of diffusion. And secondly, there are claims based on the infringement of Getty's intellectual property rights in relation to the outputs of the model, that is, the pseudo-images produced or generated in response to the prompts by users. More specifically, Getty contends that there is a likelihood that diffusion will generate images which will reproduce the Getty trademark, and that the association of the Getty trademarks with the content of some of those images will tarnish the reputation of the Getty trademarks. This appeal concerns a ruling made on an application on the first day of the trial as to how Getty may seek to prove that tarnishment claim. Now, my lords will have received, I anticipate, and I should have clarified this at the outset, skeleton arguments from both parties, and together with a core bundle and a supplemental bundle from the appellant and a supplemental bundle from the respondent, which go into certain background matters in quite considerable detail.
Yes.
I don't propose to, as it were, bespeak what we have set out in our skeleton, and I don't believe it is necessary for the purposes of this application to go to any of the evidence or disclosure referred to there. Certainly, I don't believe it's necessary to do so in any detail or to any substantial extent. And what I propose to do, if that commends itself to my lords, is to start by looking at the order under appeal, which is in the core bundle behind tab 4 at page 37.
Yes, I think we both have some grasp of what the issue is that arises, and in particular whether the plea about tarnishment as a result of pornography extends to child sexual abuse material. And there are other issues related to that, such as, well, what is the significance of the examples which were then pleaded in the light of what was said at the case management conference on, was it the 30th of April?
30th of April, yes.
So we're certainly up to speed so far as that is concerned, but obviously you'll need to fill in the extra background that you want us to be aware of.
My Lord, I'm obliged.
Speaking for myself, I have looked at the images which are referred to in the example, so I know what they are about. I think my Lord has too.
Yes.
So I think with that indication, this is a short point and one that I can, and indeed, given the time allowed for it, I'm obliged to take shortly. One starts then with the order. It relates to allegations set out in Getty's trial skeleton. One sees from the first recital that it concerns allegations in the plural. There are more than one allegation, and there are, it is said, one sees two limbs to the order. Paragraph 1 of the order is a direct declaration as to the scope of Getty's pleading. Paragraph 2 of the order is a prohibition on Getty deploying the allegations in support of its case. And one notes that paragraph 2 begins with the word accordingly. Paragraph 2 is said to follow, in other words, from the declaration in paragraph 1. As to the allegations, one finds them in the Getty trial skeleton, which is in the appellant's supplemental bundle behind tab 12.
Before we get there, are you placing weight on that accordingly word in the sense that if the judge is right to say that the allegations are not pleaded, are you seeking still to deploy them in some way?
My Lord, yes, and I will endeavour to explain in due course why I say that is possible.
Yeah, okay. Sorry, where did you want us to go?
To the Getty trial skeleton, which is in the application supplemental bundle at tab 12, and then to the at 216, I believe, and then within that, first of all, to paragraph 5, which is at page 221 of the bundle. My Lords, to read that paragraph. And then to page 289 of the bundle, and the plea in relation to tarnishing, which starts with a citation from L'Oreal at 263, and then in material part as to what we say will tarnish the reputation of the marks, 2663 and 4, bridging pages 290 and 291. Those are the allegations, and as to how the application arose, the skeleton was served on, I think, the 30th of May, and then on the Friday, after working hours on the Friday before the first day of the trial, which started the next Monday, the matter was raised by the applicant's solicitor's Bird in a letter which one finds in the supplemental bundle behind tab 11 at page 214. That's dated the 6th of June, a week later, and I would invite my lords to read the first 2 paragraphs of that letter. What is said there, first of all, is something as to an implication as to responsibility, and secondly, that there is no pleaded case in relation to CSAM material. CSAM stands for child sexual abuse material. It's not a legal term. It's not a term which is to be found in any statute. It is the preferred and recommended term by a global interagency group, preferred term to use when referring to child pornography. On the application on the first day of the trial, Stability's leading counsel, Mr. Cardigan KC, described the point which he was raising as a pleading point. I can give the reference, I don't think it's necessary to go to that. One sees that in the transcript in the appellant supplemental bundle behind tab 1 at page 3. The relevant pleading is paragraph 57.9 of the current particulars of claim, and one finds that in the core bundle behind tab 8 at page 51.
89, I think.
I was giving, my lord's correct, I was giving the page of the pleading.
Oh, that's 39 on mine. But anyway, it's 57.9, which is the one with the blue amendment. Is that right?
Oh, sorry, my lord, I was giving a page reference. Yes. Yes, 57.9 is the relevant paragraph. Paragraph 57.9, we say, describes the kinds of images an association with which Getty claims is likely to tarnish the reputation of its trademark. Paragraph 57.9 does not say or set out a case as to why the model is likely to generate such images. For all I know, which is saying very little, it may be impossible to avoid it. The acronym CSAM, the acronym CSAM, does not appear in paragraph 57.9. The question is whether CSAM, that is child pornography, is a kind of pornography within the meaning of the term pornography as used in paragraph 57.9. And the starting point is the ordinary meaning, and the ordinary meaning, as one may take it from dictionary definitions, and we are very grateful for the email we received from my Lord Justice Mayall's clerk this morning, drawing our attention to the definition in the OED, a copy of which I believe has been provided to you.
Right. Well, as you might have inferred from that, we are, at least provisionally, minded to think that pornography is a term which is wide enough to encompass the kind of images of sexual abuse of children, which is also encompassed by CSAM. But your pleading goes on to say examples of such images, and the examples given are very far from that kind of material, and therefore, in the context of what was said at the CMC, why should those examples not be taken as broadly representative of the case which you were setting out to make?
That is a critical point, and the point that I will come to next.
Yeah, okay.
Before leaving what may be the obvious point, which is that child pornography is a form of pornography, and this court is unlikely to wish to declare anything to the contrary, I just draw attention in the extract from the OED and the section on pornography to the reference at the top of page 2 to the second point there in relation to the sentencing in 2005. Sentence has been set for a man who pleaded guilty to downloading child pornography on a work computer. That is, of course, CSAM. I come then to the examples, and one notes first in relation to the examples that they are in blue. They come in as an amendment on the 6th of May this year. The amendment was made following a CMC on the 30th of April. And it's important, we say, to understand the function which the examples pleaded in paragraph 57.9 serve. You will have seen the extracts from the transcript of the CMC set out in paragraph 25 of my learned friend's skeleton. However, in order to understand the function which the examples serve, it's necessary to zoom out a bit. And one finds the fuller transcript in my learned friend's supplemental bundle behind tab 5. At page 46 of the bundle. The first passage I would draw to my Lord's attention is at the bottom of page 10, going over, that's internal page 10, going over to page 11. If one starts, probably one can start around line 20 of page 10 and read on.
With the judge's comment?
My Lord, yes. It may be simple if one then just actually reads to the bottom of that page rather than my seeking to select particular passages from what's quite a short passage in itself.
Yes.
And one has, time permitting, if it is a critical issue, to read the fuller transcript. But it's in that context that one then sees what is said in the passage that's relied on by my learned friend on page 13 of the transcript. So that's on the next page at lines 13 to 15. So,
yes. Well, this is all in the context of what are called not safe for work images, which is, I would have thought, an unduly light-hearted way of talking about child sexual abuse material.
Lord, what we say is that this is concerned not with the particularization of the claim, but with the ways in which those claims may be proven. The point that Mr. Cuddigan is making is that he shouldn't be surprised in closing by the production of a particular image that has been created in the course of the trial or pulled from disclosure and is relied upon as evidence in itself in some way. Is asking to know what the evidence of that kind will be, and he expressly states.
Well, how could you produce an image of child sexual abuse material in the course of the trial without committing a criminal offence?
Well, Lord, it is possible because there's an exception to the general provisions which say that the making or possessing of such materials is an offence where one has a legitimate...
That's for possessing, but not for making.
Well, let me step back, my lord, because I do not claim to be, and my submission will be that one doesn't need to be an expert on the understanding of the circumstances in which one may be held liable under the Children's Act 1978 in order to participate in this trial or to resolve the issues before the court today. The evidence by which it is sought to prove the case is not confined to particular images. My learned friend says it's a hopeless case, and if he's right, of course, in due course, he will succeed. But that's not the issue before the Court of Appeal today. That is an issue for the judge at first instance. What we say is that one has first to establish the nature of the pleaded allegation. And the question of how one may then prove that is in the ordinary way a separate question. Now, of course, where one is dealing with a late application to amend, then the question as to the prospect of success may well be taken into account on an application of that kind. But this is not an application to amend that is the subject of this appeal. And therefore, for these purposes, one must make a distinction between the issues of pleading and the issues of evidence, as indeed the judge below expressly did, save where, as a matter of pleading, the case has been cut down by express reference to the evidence. So it could be that the pleading stated something in very general terms, and then, by way of particulars, as it were, referred to an expert report or a witness statement or whatever. And if the examples were being used in that way, then they would affect the scope of the pleading. But unless they are being used in that way, the scope of the pleading should be the same as it was when it was originally pled. And of course, there is no attempt here to say that we can't run a case in relation to violent images or material which is to be regarded as propaganda. And none of the images are of a violent nature or of in the nature of propaganda. But Lord Justice Mills is, of course, with respect, correct. Issues will arise, however they might be resolvable, in relation to the production of specific examples of pornographic material. Not least how one manages that within the trial teams that are having to advance the case. But that's only a fundamental problem to the case if the production of such images is the only way by which one can prove that such images are likely to be produced. Of course, it would be a very straightforward way of doing it, but it's by no means the only way. Again, I hasten to add that I deal with this matter very much intuitively, because I'm not on top of the evidence, but one can immediately see that there are a number of things that could affect the kinds of image that can be produced, what went in the first place, how it was trained, the nature of the model, the nature of the filtering systems. These are things on which evidence could be given by experts or by witnesses, and it may well be, one would hope that at least some of the stability witnesses are in a position to assist us. We may not like the answers, but as a matter of principle, and when it comes to considering the pleading, we could establish our case by admission.
What do you say is the purpose and effect of the Blue Amendment?
The purpose of the Blue Amendment is to ensure that no specific examples, which might need to be considered in detail, are produced, as it were, as a rabbit out of the hat. So, for example, where we attempt to prove the case by saying, look, this is what's been generated, you've got a particular case, there may be a number of riposts, a challenge to whether it was done that way at all, a challenge to the fairness of the prompt, a challenge to the representative nature of the prompt. You know, is this something which there is a sufficient likelihood of anyone actually inputting to get this output? And where the case is based on a specific image which it is said has been actually generated, it's entirely reasonable that they should wish to know in advance what the images are in order that they may consider what the specific response is in relation to that specific example. But what is, we say, entirely clear is that the case, that is, Getty's case, was not confined to what could be proved by reference to the images. And one sees that acknowledged at page 13, lines 11 to 15, acknowledged by Mr. Culligan. He says, well, first of all, that reference is to what he's asking for. The defendant is entitled to know if you're relying on specific examples of images.
I beg your pardon, can you give me the reference again?
Well, I need to open up the...
I think what you're quoting was the judge.
I realised that I was quoting...
It's page 47 of the Respondent supplement.
I need to go back to the relevant paragraph of the relevant part of the transcript. I'm grateful. It's page 47, I was on the wrong page, at line 13. Sorry, if I may. Oh, sorry, it's internal page 13.
Yes, it's the judge saying, I follow that, but I think that the defendant is entitled to know if you are relying on specific examples of images that you say go to that plea, that they should be identified. That's what you wanted, isn't it?
Lord, no, the quote that I'm missing is where Mr. Cardigan acknowledges.
Perhaps you want the bottom of the previous page, 46.
Yeah. Yes. I'm afraid that in this light my eyes are failing with the small print. So, if it is saying what I believe, yes, sorry. What one sees there is a recognition that we may rely on our expert evidence. And it is perfectly possible to prove a case as a matter of principle without any specific images. And indeed, in relation to violent images and in relation to propaganda, it will be clear to everyone that that is what we're seeking to do, since there are no images in the case, specific images, that fall into that category. So we say that on a fair reading of the function fulfilled by those examples, it is not narrowing the original claims. And in the absence of any amendment to the list of example images, there will be no CSAM image relied upon in support of paragraph 59.7, regardless of whether or not paragraph 57.9 rather encompasses CSAM. Now, with that introduction, I want to, if I may, turn to the judgment, which one sees in the core bundle behind tab 5.
Yeah, I'm a little alarmed by the word introduction, Mr. Bloch. We have 2 hours set aside for this appeal, maximum, which means that you have about 1 of those hours.
My Lord, I should not have used the word introduction. I believe we are covering the
We're
ground.
well into it, hopefully.
Yes. So, paragraph 4 of the judgment, page 39 of the bundle, sets out Ms. Bohill's submission that CSAM is effectively a subset of the concepts of pornography and violent imagery. As a matter of language, she is obviously right about this. At paragraph 5, the judge summarises Stability's submission that it would be importing an apparent allegation of criminal conduct. Of course, my friend Mr. Cardigan is also correct in a sense. CSAM is a kind of pornography, the production or possession of which is, in the absence of a justification recognised at law, an offence under the 78 Act. There are many kinds of pornography which may be the subject of criminal offence. Some such offences are contained in the 78 Act, others are in the Criminal Justice and Immigration Act, 2008, but I don't believe there is any issue between the parties. It's the fact there are a number of such offences. Getty is not alleging or seeking to allege that Stability is criminally responsible for what a minority of its users, I might say perverted users, may do with diffusion. The offence is committed by those users who prompt the model to produce CSAM, just in the same way as it is they, rather than Stability, who may choose what prompts they use and thereby generate, if we're right, other forms of pornography and violent images and images of the nature of propaganda. Of course, from Getty's perspective, if and when the offending images are put in circulation, the damage is the same. One then turns to paragraph 8 of the judgment. One sees there what the judge refers to in parentheses to assist in her construction. And of course, there are numerous examples of these authorities in the authorities bundle. We accept that if Getty wished to allege that the Stability's conduct is criminal, it would have to spell it out. However, the line of authorities to which the judge refers and on which Stability relies are all concerned with serious allegations made against the other party in the proceedings. The authorities on which the judge relies are not concerned to give notice to the anonymous perverts who Getty is alleging are likely to commit the offences by using diffusion in a particular way. In paragraph 10, we see the judge refers to the idea that the evidence served in relation to a pleaded issue cannot change the scope of the pleaded issue. We, of course, respectfully agree. The meaning of a pleading is a matter of law, at least in the extended sense in which any issue of construction is a matter of law. And it's because it's a matter of law that an error of construction may vitiate the exercise of a case management power. One then turns to paragraph 14. You see what the judge says there is clear. He says it's clear that pornography does not include criminal pornography. That's her conclusion. Her reasons for saying that are quite brief. It may be that she is referring back to what she said about serious allegations, and you have my submissions as to her error there. The only thing to which the judge refers expressly is the examples. We accept there is no CSAM example pleaded in paragraph 57.9, so the judge is right if and insofar as she's saying that the examples do not assist us. However, the judge is wrong if she's saying that the absence of any CSAM examples points to a narrow reading of paragraph 57.9, and you have our submissions as to what function those examples, why it was that those examples have been pleaded. There's nothing that one sees in the transcript of the hearing on the 30th of April which would justify that being interpreted as a means of defining the scope of the pleading to which that evidence is intended to go. And it's always dangerous to appeal to common sense. There are two respects in which we submit that Getty's construction is the only one which accords with common sense. First, take an image, hypothetically of course, which Getty puts forward as an example of adult pornography. Could Stability seriously argue that the image should be disregarded because it could be seen as an image of child pornography? If they're right, whilst the matter may not arise, it would be a defence to the claim as pleaded. And that would be somewhat absurd. Secondly, and relatedly, it should be obvious that an association with child pornography is at least as likely to tarnish the Getty trademarks as other forms of pornography. So unless the special rules in relation to serious allegations are engaged here, child pornography should be seen as an obvious example of the kind of thing which worries Getty. Look, I should perhaps make it clear that we are not seeking to run a specific case in relation to CSAM. I should emphasise...
Sorry, what does that mean?
Well, I'll endeavour to explain. Getty simply wishes to rely on evidence of the likelihood of the model generating CSAM images in support of its case as regards the likelihood of the model generating any form of pornographic image. It may be said, and I don't know, I'm not sufficiently on top of the way in which the defence is being run in the trial, that whilst some images of an undesirable nature may be thrown up despite filtering where there are inappropriate prompts entered by users, the number is so small that it should be discounted. And there's a little bit of salami slicing going on here, because they're saying, well, just look at a subset of pornography when considering whether the number is in fact so small. We say, not that CSAM should be given, as it were, is a category of its own, but that it's a form of pornography. And when considering whether there is sufficient risk of such images being generated, whatever that standard may be, CSAM images, insofar as there is evidence that they will be generated, should be included in the scales along with other forms of pornography, and of course, propaganda and images of violence. Now, my lords, I should turn to paragraph 2 of the order and deal, if I may, subject to any further questions in relation to the submissions I've made today, with the question of what follows if CSAM isn't within paragraph 57(9).
Well, just before we get into the detail of that, is this a ground of appeal? We challenge both paragraphs of the order, and we do say that the judge erred in the way she applied the line of authorities in relation to the making of serious allegations and pleading them out. Yes, but let me be specific. Your grounds of appeal, as I understand at the moment, are both challenging paragraph 1. If you win on paragraph 1, then obviously paragraph 2 goes. Assume for the moment that you lose on paragraph 1, can you independently attack paragraph 2? Because at the moment I don't see any ground of appeal which independently attacks paragraph 2.
And I would add that I don't see anything in your skeleton argument which makes that case, but if there is something there, you'll show it to us.
If there is something there, it will be drawn to my attention by those behind me. I acknowledge that the way that my Lord or Justice Arnold has analysed our grounds is accurate. I would, and I'm not, I suspect, going to be well received if I seek to formulate a further ground on my feet. That said, there are a couple of things that I would say about this which feed into two aspects of the case and the grounds that we currently have before us. First of all, my own friend says this is all really a case management matter. I'm, of course, take a different position, but insofar as it is a case management matter, one needs to understand how the determination of the paragraph 1 issue on the first day of the trial is going to work, given that the allegations are, in fact, compound and not set out as a pleading, and that, as I understand it, whilst the allegations, whatever they may be, would then not be something we could deploy, there has been already reference in the trial and in the cross-examination of Getty's witnesses by Stability, reference to CSAM material. And even if you do not use the acronym CSAM, issues are going to arise. And if I may very briefly explain why we say this is a matter of concern. The judge determined this matter on the first day of the trial without a formal application, with the intention, as one sees, I think, from paragraph 17, or paragraph 21 of her judgment, to ensure that everyone knew exactly where they stood. But, in fact, that is far from clear. And that, if I may just give one example.
Mr. Block, I'm a bit puzzled by all of this. Surely the case management consequences of the ruling, if it is upheld, are a matter for the judge. What we're here to do is to determine the correctness of the ruling.
Well, my Lord, that is of course correct, but if I may just, because I know this is a considerable concern to those who are conducting the trial, at least articulate my concern, and my Lords may then dismiss it. Take a document in disclosure which says, a document produced by a Stability witness, and it says that there have been real issues in relation to CSAM, and that it hasn't been possible to remove it all from the data set or filter for it effectively. One possible line of cross-examination would be to put it to the witness that if there's a problem in relation to CSAM, there was likely to be a problem with pornography more generally. Another possible line of cross-examination would be to put it to the witness that if there was a CSAM problem, it's likely to be the tip of the iceberg when it comes to pornography more generally. A third line of cross-examination would simply be to remind the witness of what he has said and ask him, in the light of that, whether he would acknowledge that there is an ongoing problem in relation to non-illegal pornography and whether the steps taken in relation to non-illegal pornography were different from such steps, if any, as were taken in relation to CSAM. And the reason I raise this, of course, it is twofold. One, which I believe is probably not open to me, and that would be to point out that paragraph 2 of the order, in fact, does not follow from paragraph 1. But also to point out that far from the ruling meaning that everyone knows exactly where they stand, that's not the case. So if insofar as case management considerations affect the determination of this appeal in relation to paragraph 1, one should take that into account.
Is the example you've just given a purely hypothetical example, or do you have a document in mind which says roughly what you said?
Lord, I understand that it is not a misleading hypothetical example, but I do not have a particular document that I seek to draw to the court's attention. But it is, if it's not in precisely those terms, it's documents of that kind which one would wish to put to the stability witnesses. And the fundamental problem that's occurred here is there's been an attempt to deal exhaustively and pretty much on the hoof with issues which will come up in very nuanced ways in the course of the proceedings. Now, we are not asking for carte blanche. We're not asking for a blank check to be able to refer either expressly in open court or even without specific reference to CSAM or CSAM materials. Of course, there will be an ongoing function for the judge in checking and ensuring that nothing oppressive, scandalous, or unfair is done by deploying this material. But there will be documents, and this I think I can say without being gainsaid, where, for example, the acronym CSAM appears together with the acronym NSFW. Are we able to use those documents? Are we supposed to redact for one reference? These are matters which can only properly be dealt with as and when they arise in the course of the trial. So, in conclusion, my lords, we say this is essentially a matter of construction, and you have our construction. But if it is appropriate to consider case management considerations as my learned friends contend, then this is actually a recipe for considerable injustice, since it cannot properly anticipate the issues that will arise in the course of the trial, and in relation to which it's necessary to give separate consideration if my clients, Getty, are to have a fair opportunity to put their case. My lords, unless I can assist you further.
Thank you very much, Mr. Bloch. Mr. Saunders.
My lords, as I'm sure you both apprehend, this is an extremely serious allegation in respect to a matter which my client finds absolutely abhorrent and which it takes very seriously. My learned friend in his submissions a moment ago was talking about anonymous perverts using diffusion in a particular way, prompting the model to produce CSAM. Well, the answer is, how on earth is that being alleged to be done? Because as Mr. Ayres explains in his supplemental, the evidence which is in the supplemental bundle, that was produced for the amendment application on this. Stability employ third parties to stop this happening. They filter data when the model is trained to stop this happening, and they control the outputs to stop it happening. None of that is in evidence in the trial at the moment, because this was not considered by Stability to be a point in issue. Nor, for that matter, was it considered to be a point in issue by the judge, who said, as my lords have seen, I'm sure, in her amendment judgment, it was caught her by surprise too. My lords, two other background points. This is a point about the outputs of the stable diffusion model. There's no pleading on the training of the model on CSAM. And also just correct that the model is called stable diffusion, not diffusion, as one of the friend referred to it. One other preliminary point, as Lord Justice Arnold observed, the consequences of my Lord's decision today are a matter for the trial judge. Obviously, it's for her to decide how best to deal with that. And these sorts of issues which my learned friend was referring to in terms of the micromanagement of allegations during cross-examination are, in my submission, not something this court can really delve into. It's the question of principle that matters. So with those points in mind, I was proposing to structure my submissions in three parts. The first is the pleadings, how we got there and the approach to construction. The second is Getty's contention that CSAM is already in the case in some way. And then thirdly, a couple of specific points on the grounds relied upon. My lords, I think you've seen the pleadings in some detail. If I can just pick up a couple of points. This is a case which has been very extensively case managed by the court. The judge remarked in an earlier judgment, this case has been unprecedented in her experience in the amount of judicial time that has been required to case manage it. There have been 10 hearings, 28 orders and 14 judgments. Now, that obviously doesn't tell you an answer to whether the judge was right or wrong on this individual occasion, but what one can take from this is she is intimately aware with the scope of the pleadings and the issues as they arise. And if I can just draw out a couple of points in addition to those which my own friend drew out in the pleadings, we could just take up the core bundle at tab 8. So this is in the context of a trademark infringement plea. You need to start with paragraph 50, which is on page 82. So there it is alleged that in some cases the synthetic image output bears the sign Getty Image and or iStock as a watermark. That's page 82 in the bundle. So in some cases. Now, and then it goes on to identify various examples that have been produced. And there was a great exercise in this case, and there are some experiments in there as well as to how this material and the circumstances in which it does or doesn't get produced. The trademark infringement plea itself is at paragraph 56 on page 87. And that says, further alternatively, by reason of the matters set above at paragraph 50, i.e. the inclusion of Getty Images or iStock as a watermark, that is the reference back, the defendant has infringed. So we're dealing with an allegation that obviously the sign that is complained about has to be used. The allegation is where there is a watermark attached to the image. And then you'll see at 56.3 the plea, which is in the most nebulous of forms, essentially it just follows the statutory language. I'm sure Justice Arnold will observe. And then we get over to 57.9 on page 89, which we saw a moment ago. Now, when this came back, we came before the court in April, my lords have been taken to the exchange in with the judge about how this issue arose. If I may, I'll just take you back there and just draw out a couple of other points which relate to that. So that's the supplemental bundle, tab 5, so the respondent supplemental, tab 5, page 46. Now, there have been a lot of hearings in this case, or several hearings in this case, about the pleadings and the scope of the pleadings, whether certain things can stand as examples, whether they're exactly how the trial should take place by way of sampling or otherwise. And that is the context behind which Mr. Cuddigan makes the submission on page 46 of the bundle, manuscript page 10. If there are material facts that you're going to rely on, you set them out in your pleadings. If you look at this part of the case, it's all mere assertion. Then he goes on, my submission quite rightly, so it puts us in a hard position because we have to prove a negative. At the moment, we have to prove that there's never been what is meant by pornographic image generated by stable diffusion. It's impossible to do. My own friend said there are other bits from disclosure. There is a vast morass of disclosure. It's obviously appropriate if they have examples that they put us on notice. And that was essentially the complaint that was being made. There was then an exchange, which my lords have been taken to. The judge gave the indication which we quoted in the skeleton. And then just over the page 47, you'll see just at the top of page 12, the judge says, okay, Ms. Lane, I think that addresses the point. In my view, you do need to plead the two concrete examples which you show this assertion is correct. You do not need to plead, in my view, that your expert evidence will establish this because you have an assertion which your expert evidence then goes to. Yes, says Miss Lane, just to be absolutely crystal clear, I'm pretty certain that in the evidence of Mr. Stanley, someone will tell me if I've got it wrong, there is a whole exhibit containing not safe for work examples, of which these Miley Cyrus ones are only two. And then it goes on. The judge then in page 13 says, well, that's the way litigation should be conducted, is the matters which a party wishes to rely upon are identified in the pleadings, so the other side knows what case it has to meet. Seems on that there's happy consensus, exactly. Didn't mean to interrupt, but this is why we've pleaded stable diffusion can be used to create images that contain pornography. But the defendant is entitled to know, says the judge, if you're relying on specific examples of images you say that go to the plea, they should be identified. Now, so that is the background that led to the introduction of the plea that you see in blue on core bundle page 89. So they then pleaded the exhibit to Mr. Stanley, which was the exhibit that Miss Lane was referring to on her feet, and Annex 8H. Now,
just to step back,
yes.
before we get to the blue amendment, do you accept that the word pornography includes both child sexual abuse material and, for that matter, things like bestiality, extreme pornography, as it's called, which is also possession of which is also criminal?
Well, my lord, we say that it doesn't include illegal forms of pornography, the possession of which is illegal, as a matter of instruction.
So pornography does not include illegal forms of pornography.
Well, my lord, in the context that there's a distinction between a dictionary definition and the role of a pleading in a case. I'll come on to it if I may address you in relation to that in a moment. But we say that pleadings are not to be approached as if they were a statute. Certainly one's guided by the normal natural meaning of words. That would be a very peculiar outcome if that were the case. But much like a contract, the overly literal approach to construing a contract is not determinative. It's to be construed in the context of the matrix of fact following the investors' compensation scheme and all the authorities which our Lord's extremely familiar with. The context here is not only that this particular document is a document that has a purpose of defining and putting critically the defendant on notice of the issues it has to meet in a case, that is the principal purpose.
So is it your distinction that the claimant's case on the unamended pleading, that's to say without blue, always required the court to be constantly asking the question, is the pornography in question legal or illegal? And how on earth was the court ever supposed to do that?
Well, my lord, I'll put the point a slightly different way. The plea is not a plea that illegal material is relied upon in support of that plea. Ordinarily, when you plead something that relies upon illegality, that is something which would be set out. For example, if you plead you rely on property, it doesn't ordinarily, as a matter of construction, would include illegal property. That is something that has to be identified. Similarly, if a defendant is alleged to in any way be at risk of something which is illegal, let alone something which is criminally illegal, then that is something which is ordinarily pleaded expressly. What we actually had in the original black text was a plea, as Mr. Cuddigan said in submissions, it was wholly nebulous and uncertain. And that is the reason why the issue came to a head in April, to try and elucidate the scope of that plea.
It comes together with violence, which is almost by definition illegal.
Well, it depends on, I mean, an image of violence may not necessarily be, my lord. I mean, a lot of Hollywood films would fall foul of that if it were a fundamental problem. I mean, it's certainly not saying that in some circumstances a depiction may be illegal. But
well, so if it generates an image showing violence, if it's taken from a Hollywood film where it's all just good fun, that's covered by the pleading, is it? But if it's a real fight going on in a street where people are getting hurt or killed, that's not covered.
Well, my lord, it just depends on the context, and I appreciate. I mean, the difficulty is what we're trying. This is a plea which is, in my submission, very vague to begin with, and to suggest that it isn't.
I'm just testing why you interpret this as meaning legal.
Well, I think, my lord, because there is no allegation within the plea, an express allegation that includes illegal material, the possession of which is illegal. And that is of a nature which would require two things. Firstly, very clear and careful case management directions, not least because in criminals we understand from criminal practitioners in this area, the court has to give directions so the defence counsel can even see the material and handle it. So that's certainly not something that anybody, for a moment, and certainly Getty never suggested would need to be done. But secondly, because that is the reason why this is a point which was raised, and Getty elucidated their position in the way that they did by providing the examples. And my lord, you have to look at the pleading as they have chosen to advance their case, not in the abstract. I mean, there was a question of...
Yes, well, I was taking it by steps to see what it meant in the first place before the blue.
Well, our position was
and then whether it is narrowed by the blue or not.
The answer is we didn't understand it fully, but our position, if it were one, were that it didn't include illegal material.
Okay.
Because that is not expressly said. But in any event, my lord, we then have the addition of those materials. Now, my lords have indicated that you've seen those examples. They are a long way in my submission from child sexual abuse material, but critically they do something else, which is not just the images. What they include are the versions of Stable Diffusion relied upon and the text prompt that is used to generate the image that is relied upon. But that is critical because for the defendant to understand the case that it has to meet, it needs to know what was being said in all, what should be inputted into the model in order to generate an offending image that is said to contain the Getty watermark. That is what we're concerned about. So it is not possible for the defendant to, and there's no proper allegation of material facts without that critical piece of information, which is, I think, in the first of the three columns. The second is the image, and the third is the version of Stable Diffusion. So that is why the examples have a force, because they are capable of being interrogated. And that is why a nebulous allegation does not work in the context of this case. And we have been through that debate a lot of times by reason of the various experiments and various other matters that have come up at various previous CMCs. So the key thing is what prompt is said to offend. Now, my lords, there is of course no reference in the April transcript to any intention on the part of Getty to advance the case of CSAM, extreme pornography, or any other unlawful material. We say that is very striking. It's also very striking that they didn't go off and seek directions in relation to that. That would have required some careful handling by the judge to make sure that a suitable ring was put in place so this material could be adjudicated upon. none of that was done. The reason being that no one foresaw that this was within the scope of the pleading. It's a very clear indication that no one thought at that stage that this was a key thing. Now, my lords, there was then our defence. That alleged, amongst other things, that these are contrived images and they're not use of a trademark as a trademark, which is a particular defence to infringement. And then a reply was filed, and if we could just look at that briefly. Core tab 10, page 184. And then you'll see the new, my lords, do you have that page 184? And then you'll see some purple text. This was the new material that was added following the reply. The final three sentences, so paragraph...
This is in response to the blue amendment.
No, this is the claimant's reply to the defendant's pleading.
Sorry, but it follows the blue amendment.
Yes,
Sorry, I said it wrong.
Yes, I'm sorry.
Yes,
Yeah.
no,
So this is the claimant again, and clarifying its case. As to the, so paragraph 110, little Roman 3, is where, amongst other things, the defendants plead back to that allegation. They say they repeat various paragraphs. It's denied that the allegations of tarnishing are unparticularised. However, for the avoidance of doubt, the claimants will contend as follows. 69.1. The images identified in paragraph 57.9 are not safe for work. Having regard to the content of the images, specifically 1, the depiction of nudity, and or 2, the particular poses and actions of the persons depicted. My lords, if you're looking for, it's page 149, if my Lord Justice Arnold is winding backwards to look at the defence. But I don't need to go there particularly.
Is not safe for work a defined term, and
no,
who defines it?
It's not, although not safe for work doesn't normally mean material, as my Lord I think has already observed, the mere possession of which is illegal, let alone the making of which is illegal.
Well, surely that would be a paradigm instance of not safe for work.
Well, my Lord, I think it's particularly unsafe for work, but it is not a term which, not safe for work, it denotes an image which, in my submission, may be otherwise permissible, but is something that isn't something that should be viewed in a modern workplace. So that is the way in which they were designated by the claimants when they produced that. But the critical point is they say the depiction of nudity and or 2, the particular poses and actions of the persons depicted. And then 69.2, further, as far as tarnishment is concerned, there's a difference between a genuine image of a celebrity or other person who's chosen his or her attire for use in a public performance and or chosen a particular pose or action, and the generation of synthetic images, bearing trademark, that do not depict a real event or where the person has not chosen his or her attire, and so on. Now, why is that there? The reason being, of course, that Getty Images website contains images of people in various states of undress whilst performing. So they say there's a distinction for purposes of tarnishment between an artificially generated image and the real McCoy. That's obviously an issue which is on the pleading, but not for now. Again, what we say is what you take from this, it is absolutely consistent with CSAN not being in the case. Now, so there is not a scintilla of the slightest mention that this included illegal conduct, both as a matter of case management, or on the evidence relied upon, or in relation to the reply. And as I said before, one can infer actually that nobody on the other side of the court had actually thought about the consequences if this illegal material were being relied upon, because some very careful case management directions would have been needed. Now, my lords, you will have seen from the skeleton, we also rely on a number of aspects of the subsequent procedural history following this particular.
But how can that be relevant? Because this is an issue of construction of the pleading as at the date of first day of trial.
Yeah, my lord, yes, but it is relevant because the judge considers her earlier judgment in the later.
But obviously on the premise that she was right about the interpretation of the existing.
Yes, I mean, my lord, I don't.
If she was wrong about that,
No,
then
I don't put any weight on the fact the judge said it twice. That doesn't, that in itself doesn't get me home.
But also she was concerned to explore the consequences of the ruling that's under appeal.
Well, my lord, in my submission, she does slightly more than that, because in order to try and get the amendment in, Getty referred to in its evidence the material that they say is already in the case and gets them home. The judge held, as we set out in the skeleton argument, that wasn't sufficient to support an amendment. She agreed with me that that test was not met.
Well, if she's right about that, then why are you worried whether it comes in or not? If it comes in, the judge has said you're going to win anyway.
Well, my lord, because this is an extremely serious allegation, both parties are agreed that if it comes in, the trial will have to be adjourned. Because this has not been dealt with in evidence.
Well, the claimants have dealt with it in evidence. They put in their evidence, and the judge has told them it's not good enough.
Well, my lord, I'm surprised to hear my own friend disputing that, because on the amendment application, Mr. Rose put in a statement saying that if necessary, it will have to result in adjournment, and Mr. Ayres, for the solicitor for the defendants, on instruction, said that Stability would want to put in the sorts of evidence which I've already alluded to, and there simply has been none of that in the case so far. What we have got is I'll address you, if I may, in a second, about what's actually already in the case, but very peripheral inclusion, incidental inclusion, as it were, of this material.
But again, like Mr. Bloch, you seem to be going into case management consequences of the ruling rather than what we're actually concerned with, which is the ruling on the scope of the pleading right or wrong?
Well, my lord, but the point I'm trying to develop, which may not be hitting home terribly effectively, perhaps, but is that the pleading cannot be considered in the abstract. It is not an erudite question of whether one construes the word pornography in a particular way. One has to look at it as a creature of procedure and as a creature of regulating the issues between the parties in the context of what has been a very heavily case-managed case. It's also the product of of clarifications along the lines that my lords have seen in the pleadings I've just addressed you on. What you don't see in any of that is the kind of material of a genus which would support illegality or let alone CSAM. Now, Getty could have come to the court and said, right, we want to run a CSAM allegation, but we're going to have to seek some prospective directions from the court to enable us to run it. These are the prompts that we say that should be included, and we would like to be able to generate that material and hold it for the purposes of this trial. That was never done. And you can see from the exchanges I just took my lords to that this was on no one's mind on the other side of the court at all at that stage in time, because Miss Lane was talking about not safe for work material. And here we see an SFW material, which certainly in the context in which that term has been used here, has been used as not safe for work, but otherwise legal material. And you can see that from the examples themselves.
I have great difficulty in understanding what directions could have been given which could have lawfully authorised the production of child sexual abuse images which did not already exist.
Well, my lord, that may be right if it were possible for the model to make them. That is a heavily disputed issue, as I've already adjudicated. Oh, sorry, already submitted. But if there is other material out there that is said to be CSAM, then pre-existing material, the holding of which is potentially illegal, then, as in a criminal trial, there would need to be some sort of direction given. Call it a get-out-of-jail card, but some sort of actual direction to say that for the purposes of this trial, that material can be held on provision of a suitable undertaking by the recipients of the material, is what's normally, as I understand, done in a criminal case. But, my lord, so we say that that decision is important because this is part of a series of exchanges at the beginning of a trial, and the subsequent, although the application was brought on the premise that they were unsuccessful at first, it does traverse some of the same issues in the case, and also critically contain the judge's ruling on the state of the evidence. And the other point which we do place some weight on is the exchange which we quoted in our skeleton argument with Getty's counsel, that they get home on tarnishing just on pornography. CSAM is not going to win us the day if pornography has not. Now, as a matter of case management, why permit CSAM to be introduced, with the effect of which will be to derail a very large and complicated trial in the Chancery Division?
Well, that's a very good reason for the judge refusing the amendment application. That's on the premise that it's not there.
Yes, well,
It needs an amendment to bring it in.
Yes, but that's well, we would, and I think I submitted at the time, it was terminal to the amendment application, actually, because as a matter of case management, how on earth can you reduce that? But it is also, we would say, that admission that this is not necessary is also quite important as far as the consequences of the construction of that pleading is concerned, because whilst it's easy to, as it were, divorce this from reality and have an erudite debate about dictionary definitions or so on, this is a pleading in the context of a heavily case-managed case, and that is something which the consequences and management of that pleading is something which the court has been very closely involved in at various times. My Lord, can I just address you, if I may, on the definitions point? Now, I know my learned friends in their skeleton argument had various definitions of the task force on child labour and UN treaties and so on. Now, we say it's not a matter of those things, and I noticed my learned friend didn't go to them. I don't think they're even in the authorities bundle. If they had been expressly referenced, that might be one thing, but they haven't been. But more generally, we submit that pleadings have a fundamentally different role to construing them as if they were a statute or a contract. They are creatures of litigation, but critically, they are there under the rules to demarcate the issues and ensure the parties are not surprised by a case that they didn't know they had to meet. And the pleading of material facts, which was the debate that we saw at that CMC, is all part of that. And if I could just take you very briefly to Mr. Justice Mead's decision in Lenovo and Ericsson, he puts it rather succinctly, which says the respondent's authorities, tab 9, page 225. So it's just the bottom of paragraph 12 on page 225. So there was a debate there where an expert evidence had extended beyond the pleaded case. And you'll see that that is not how the Patents Court proceeds. The Patents Court is no different. So I'm just reading from the end of paragraph 12. The Patents Court is no different from any other branch of the High Court in this respect. The pleadings are there to avoid surprise and to manage the proceedings sufficiently in a cards-on-the-table way. And it is completely unacceptable to present evidence which is unsupported by the pleading without any reason or explanation. And it is the cards-on-the-table approach that is critical, because somebody reading a pleading should not have to start on a process of, let alone ask this court for a process of adjudication to determine what is properly within the scope of that pleading. If it is necessary to have that debate, then one has the answer, which is it wasn't clear. The cards are not on the table. We're not sure if you're even dealing with a deck of cards at all. My Lord, can I...
How far do you say the examples go to restrict the case which is open to the claimant? Because they show celebrities in a state of partial or total undress.
Yes.
But there are other forms of legal pornography, which show much more distasteful
Yes,
activity.
and much more explicit, as it were, depictions than we see there. My lords, those are pleaded as an examples of the genus of material that is relied upon. We, as I say, those are the specific examples because they have identified prompts. And you may have noticed in the exchange with Miss Lane, they're the output of various experiments that were run at an earlier stage in the litigation. So what essentially was done at an earlier stage was to run a bazillion prompts through Stable Diffusion and then see what was spat out. And the claimants, it emerges, have been exploring how to contrive the system to produce certain kinds of output. Now, against that background, it's become very critical what those prompts are, because one of the things that's pleaded in defence to this is that no one in the real world actually does any of this stuff. Lawyers may do it, but that is for the purpose of proving a case, which is an unrealistic case. So it's a case produced by contrivance. So what we have is a series of examples which have been which are capable of interrogation. That they are examples of, as pleaded, not safe for work material. They are not examples of illegal material. And for my purposes, that is what we say is the delineation. There is no reliance on illegal material by the claimant. And you see that very expressly. The contents of, having regard to the content of the image, however, for the avoidance of doubt, the claimants will contend, having regard to the content of the image, specifically the depiction of nudity. So that is there.
Sorry, what were you reading from?
I'm just reading there from the reply that we were looking at a moment ago on core tab 10, page 184. You can't, I mean, it is a matter for the judge, we would submit, but you can't plead those kind of allegations by inference or innuendo. It just isn't appropriate to run those kind of points, particularly given the gravamen of the points and the consequences of the points if they're real, by way of an innuendo in a case like this.
Right, where do we go next?
My lord, so the proposition that this is already in the case. Now, there is nothing we would submit that supports the contention that these sorts of allegations, the CSAM allegations, were within the common contemplation of the court and the parties together. There are 26 issues, so there are three aspects. There's disclosure. There are 26 separate issues and an 80-page disclosure statement. There is no reference in that to extreme pornography or any other sorts of criminal content, let alone CSAM, in that document. It has not been addressed in Stability's evidence, as the judge found in the amendment application at paragraph 32. And she also found that such disclosure as there was, that had been relied upon, was incidental and arose in relation to documents that were disclosed because they were responsive to another issue in the disclosure review document, and that's the appeal judgment at paragraph 11. Now, Getty say, "Waha," there's one reference to that in the pre-processing of certain documents for disclosure. That's paragraph 10 of the appellant's skeleton argument. There were 50 terms used as a coarse grain filter to pre-process documents in one or out of 15 document repositories. That was done because that got the material down from, I think, about 900,000 odd documents down to a manageable number. And then CSAM was included as one of those terms as the pre-filter, and then the DRD terms were applied to that pool of material. There was no, the CSAM was not used as a term to search within that pool. So it is, and this is only one aspect, is one particular repository out of 15 other repositories that form the scope. And disclosure in this case has been very extensive. So as far as the next point is the trial evidence. Now, Professor Farid, who's the claimant's expert witness, makes a number of points in relation to certain CEAs, Civil Evidence Act documents that they rely upon. But critically, what he says is he is not aware of, and I'll just turn this up, it's Supplemental Bundle, tab 6, page 107.
Is this your supplement?
No, so this is the claimants supplement, I'm sorry. So this is Professor Farid's fourth expert report, page 107, and he's talking about how are training delta sets filtered. So he's using public documentation. This is the high point of the claimant's evidence. Is their expert saying, I'm not aware of any public materials which address any filtering. I'm not personally, if you look at 96, I'm not personally aware of all the filtering that took place. I do not know whether it accurately corresponds. I mean, this is essentially him saying, I don't know. I haven't seen the material that would enable me to form an opinion on that. Why has he not seen the material? Because the issue was not in the case and there's been no disclosure in relation to it. It has not been conducted in that way.
Well, in a sense, that's why I was asking, why are you bothered? He says he doesn't know, therefore you don't need to ask him any questions about it, because I say he doesn't know, and the claimants haven't proved their case.
Well, my lord, we don't, I mean, be that as it may, what we don't say is that something as serious as this should be dealt with on the fly in cross-examination of our witnesses, without having had a proper opportunity to put the right people's evidence in. Because one of the things which Mr. Ayres explains is that the right people are not before the court to address these allegations. Now, again, it's essential that Stability has a fair trial and can give evidence from the people that are best placed to deal with it. That isn't, this isn't a sort of the county court surprise. I mean, this is an extremely hard-fought case in the High Court. So we say that doesn't.
I mean, prepared in the county court.
Sorry, my lord.
I said cases are very carefully prepared.
I'm sorry. I didn't mean to disparage the county court. But
Probably a long
take that back. It's probably best.
Probably a long time since you've been there.
Now, the judgment itself, there are three strands. The first is that the judge found that the general wording does not incorporate an allegation of criminal wrongdoing in relation to CSAM. She also found that Getty could only advance its case by clearly pleading it and not extend its case through evidence of experts or documents by way of CEA notice. And finally, she said it would be unfair for them to advance these allegations at trial without giving Stability proper notice in the pleading. And that is a critical point because if they had been properly pleaded, the shape of the case at trial would be different. That answers the question of whether it is in the scope of the pleading. My lord, as far as the actual specific grounds are concerned, we submit that this is not a question of a taxonomic distinction about the words, the scope of the word pornography. One has to look at those pleadings as creatures of what they are, which is the procedure of the court, and they are intended to identify issues that the defendants must address, particularly where the criticism was that Getty must plead the facts on which it relies, and that, on any view, has not been done as far as this allegation is concerned. We say, insofar as it's important to construe that pleading, it has to be construed in the context of the procedural history which gave rise to it. All of which, in my submission, point in one way. This was, we would submit, a paradigm case management decision, of which the usual principles in JALA and so on apply. I won't address my lords on those, you've heard them many times. Sometimes, my lords, on an appeal, the respondent is in the position of saying, well, you know, this is a matter where the trial judge has exercised his or her discretion in a particular way, and while it may not be necessarily the same decision the court will have reached itself in those circumstances, the principles in JANA prevent this court from interfering with it. This is not that case. This decision is, we would submit, clearly right when one looks at the procedural context. There is no error of principle identified, we would submit, when one looks at the way that this point is developed, the way that the pleading was clarified and amended, and the approach that the judge took. Now, the second ground relates to the pleading of serious allegations. We quoted the John Zink decision of Edmund Davis, or Justice Edmund Davis, which my lords, I'm sure, have come across previously, in our skeleton at paragraph 64, page 14. Even if something falls short of criminal misconduct, it imputes a conduct of a gravely improper character, which requires particularisation. There's a similar principle that one sees in some of the competition cases, and Mrs. Justice Bacon recently in the Competition Appeal Tribunal in the Which and Qualcomm case we've also cited there as well, which identifies that, again, that is a non-criminal allegation of serious misconduct, but it is an allegation which must be properly pleaded and proved. And that is an essential part, we would submit, of the approach of this court under, well, I was going to say the Wolf reforms, but for the last 20-odd years it's been that system, that trial by surprise is not appropriate, particularly in a case like this where the technology is very complicated. My own friend said, well, he's not in a position to address it. It is very, very complicated how this model produces these images. And that is why proper notice of the material facts relied upon has to be given. This is not a case where one can just throw assertions around without giving the defendant a proper opportunity to identify what the case is being alleged against it. The technical context of this is most unusual and requires, even what a seemingly simple allegation can require quite a lot of ferreting around by experts and witnesses to get to the bottom of it. So, my lord, what we say overall is that this appeal involves addressing the pleadings outside of their procedural context. That is, in my submission, an inappropriate course. The question of whether Getty have, as it were, properly pleaded their case can be tested by the procedural consequences. How does each party's position impact on the orderly impact of the case, orderly conduct of the case, as identified in the authorities? If stability is right, the list of issues for trial is undisturbed. Of course, CSAM is not in the list of issues, which itself is a very large pointer, let alone illegal pornography in the list of issues. The trial continues on the basis understood by stability and the judge, and on the basis of disclosure and evidence as marshalled over the course of 2 years. Getty can't rely on an issue that they've declined expressly to mention in the pleadings, they haven't mentioned in hearings, they failed to bring evidence which establishes a reasonable prospect of success. If Getty's right, on the other hand, the consequence is adjournment.
Well, that's a matter for the judge, isn't it?
Well, but both parties' position before her.
That was on the amendment application, on the hypothesis that it wasn't pleaded.
Well, but what the judge accepted was that for my clients to be able to deal with the point fairly, they would have to have an opportunity to put in additional evidence. She accepted the evidence of Mr. Aries.
Well, that on the premise that the allegation was always there, which is the premise which
yes.
Mr. Block is contending for, then it will be for you to say we didn't realise that we were facing this application. We need an adjournment, and the judge would either give you one or not.
No, well, my lord, it's viewed in that in that way, yes, it's a question, as it were, of whether the decision is a two-part decision or taken in the round. But we would say that the consequences of that are very extreme in the middle of a very heavy High Court trial where witnesses are properly aligned. We say in all those circumstances, acceptable pleading practice suggests that this issue should not be maintained in this way. We certainly, as I said at the beginning, consider CSAM abhorrent, and it would be quite improper, we would submit, for these sorts of issues to be raised without giving us a fair opportunity to deal with them. That is a question of whether we are on proper notice that these issues are in the case. They are not, and that should be an end of it, in my submission. My lords, unless you have anything further.
Thank you very much. Let's look.
Lord, the judge's judgment is given on the basis that the pleadings determine the evidence, not the other way round. My learned friend seems to now be seeking, without a respondent's notice, to say in the alternative she was wrong about that, and that one should look at the evidence, the disclosure, and the procedural history to interpret the pleading. Now, we say that's wrong. We accept that there's a sense in which the purpose of the pleading, and that involves giving fair notice to the other side, informs the construction of the pleading, but not in quite the same way as the court is deciding whether to order particulars or to limit evidence or things of that kind. The purpose of the pleading is, of course, to particularize the case and enable the other side to understand the case they have to meet. But one does not judge that by seeing whether or not they in fact understood it in the way that on an objective reading it is to be understood. It is ultimately and fundamentally a matter of construction, and it is to be construed, of course, in the context of the nature of the claims objectively. Now, my learned friend says that the prompts are a critical thing to focus on when considering specific images. And he said that in the context of the significance of the examples in paragraph 57.9. But we agree that it is because in relation to the specific images one can explore whether or not their creation is fairly representative, that it is necessary, where that kind of evidence is concerned, to particularize it. But you have my submissions as to the purpose of those examples. It's the one case, we would say perhaps, where understanding the procedural history, what actually was going on at the CMC on the 30th of April, assists one in interpreting the pleading. And then, for instance, that a case we're advancing is a hopeless one. Well, I think my lords have, and indeed have put to my learned friends, points as to the relevance of that at this stage, and it may be that I need to say no more about that. Similarly, in relation to the question as to whether or not there would need to be an amendment, that would be a matter for, if we are right, Stability to make an application.
Do you mean adjournment rather than amendment?
Sorry, adjournment. I apologise, yes. Yes.
Yep, no, I understand.
Thank you, my lord. My learned friend made frequent reference to the issues in the case and the list of issues as if that would limit in some way the pleadings. The standard way in which a list of issues are produced is that they focus for the trial on things which the judge is going to be asked to decide, but they do not affect the scope of the pleadings themselves unless expressly stated. And I note that whether the model produces pornography, violent images, or propaganda is in fact not one of the issues in the list of issues. So if my learned friend is right that the list of issues is somehow taken over from the pleadings, we needn't worry about that at all. The question of filtering and what anticipation there has been of these matters is perhaps something with which the court is not going to be greatly concerned, but there is one document I should perhaps just take my lords to. I understand it is highly confidential, and I would simply invite my lords to read it. It's in the core bundle at tab 5, page 77. Sorry, I given the wrong reference. It's the appellant supplemental bundle, tab 5, page 77. And we're here in a witness statement of a stability witness, and I've just asked my lords to read to yourselves paragraph 26. But there are perhaps 3 further points I need to deal with very briefly. First, the relevance of particularization when one is concerned with tarnishment. Tarnishment takes place where the trademark owner has got a loss of control over the way in which, with the associations that may be thrown up with its trademarks. And of course, any form of pornography may have that effect if associated with our trademarks. Whether it is what people sometimes call soft porn or hard porn or any particular kind of porn within those categories. And the notion that we should, as it were, have spelt all of that out is quite contrary to what is the fundamental concern to which this claim goes. The learned friend took you to the reply and what is said there about not suitable for work images. As I understand it, the way that he is interpreting the pleading, it anticipates a submission that all of the images are simply not suitable for work rather than even pornographic, and therefore we have no case in relation to pornography at all, and presumably since none of them are in relation to violence or propaganda, there is simply no 10-3 case. That's ultimately, of course, going to be a matter if it is argued in the first instance of the judge at trial, but it illustrates the extreme way that he is seeking to salami slice what is a broad and various body of materials which may be highly prejudicial and detrimental to Getty. Finally, in relation to what you said about the use of CSAM for pre-filtering, of course, in a sense, since we are saying the pleading is to be construed objectively, this does not immediately matter. But if there was pre-filtering using the term CSAM, it cannot have been in relation either to violence or propaganda. It must have been in relation to pornography. And if Stability were correct, and one should look at the way in which the parties understood the pleading rather than just construe it objectively, one can immediately see that they appreciated that CSAM materials provided, at the very least, a relevant pre-filter. Why use as a pre-filter something which they say would throw up material so serious that they could then disregard it? Lord, unless I can assist you further.
Thank you very much. We'll rise for a short while and see where we are.
Right, my lord.
We'll wait a moment for respondents, assuming they haven't gone away altogether.
Apologise, my lord. I'm sorry.
We're going to give judgment straight away. I will ask Lord Justice Arnold to give the first judgment.
This is an appeal by the claimants against an order made by Mrs. Justice Joanna Smith on the 9th of June 2025, which was the first day of the trial of these proceedings, in which she held that the allegations advanced in paragraphs 5, 266.3 and 266.4 of the claimant's skeleton argument for trial concerning child sexual abuse material, or CSAM for short, were not pleaded in paragraph 57.9 of the claimant's re-amended particulars of claim. The background to the matter, in very brief summary, is that the claimants are, with one exception, members of a group of companies which own and operate websites such as Getty Images, which comprise millions of what are referred to as visual assets, including photographs and video footage covering a broad range of subject matter. I will refer to the claimants for short as Getty. In or around August 2022, the defendant, who I will refer to as Stability, launched a deep learning text-to-image artificial intelligence model that is used to generate synthetic images in response to text commands and image prompts entered by users. That model is called Stable Diffusion. Stable Diffusion was trained on visual assets taken from the internet, including, it is said, around 12.3 million visual assets from the Getty Images websites, as well as publicly accessible third-party websites. Getty has brought a claim against Stability for infringement of copyright, database right, trademarks, and passing off. The issue on the present appeal concerns the allegation of trademark infringement. The publicly available images on the Getty Images websites typically contain watermarks which include Getty registered trademarks. The claim of infringement with which you are concerned concerns an allegation that synthetic images produced by Stable Diffusion also include signs which are identical to or similar to Getty's trademarks. Specifically, Getty alleges that images are produced or can be produced by Stable Diffusion containing such signs which are detrimental to the reputation of the trademarks and therefore infringing within section, that conduct amounts to infringement within section 10 subsection 3 of the Trademarks Act 1994. The concept of detriment to the repute of a trademark was explained by the Court of Justice of the European Communities, as it then was, in the leading case C48707, L'Oreal SA and Valure NV, 2010 Business Law Reports 303 at paragraph 40, quote, "As regards detriment to the repute of the mark, also referred to as tarnishment or degradation, such detriment is caused when the goods or services for which the identical or similar sign is used by the third party may be perceived by the public in such a way that the trademark's power of attraction is reduced. The likelihood of such detriment may arise, in particular from the fact that the goods or services offered by the third party possess a characteristic or a quality which is liable to have a negative impact on the image of the mark," end quote. Paragraph 57.9 of the particulars of claim as re-amended on the 12th of July 2024 as alleged as follows, quote, further alternatively, stable diffusion can be used to create images that contain pornography, violent imagery, and propaganda. Any association with such content will tarnish the reputation of the trademarks and each of them, end quote. It might be thought that that pleading cried out for further particularization, but surprisingly, it might be thought, Stability made no request for further information under CPR Part 18. Stability did plead in its defence at paragraph 100.10 that, quote, paragraphs 57.7 to 57.9 are vague and embarrassing and cannot be pleaded to. No particulars supporting the allegation that Stability intended to take unfair advantage of the claimant's reputation or that use will result in dilution or tarnishment are pleaded. And so on. I needn't read the rest of that. It is against that background that there was a case management conference to which I must return before the judge on the 30th of April 2025. As a result of that case management conference, Getty re-amended its particulars of claim, specifically at paragraph 57.9, to add the following sentence, quote, examples of such images have been created using stable diffusion are at pages 20 and 100 of Annex H and confidential exhibit DAS 15 to the witness statement of David Stanley, end quote. In Getty's skeleton argument for trial, which was exchanged on the 30th of May 2025, it was alleged in paragraph 5, quote, more disturbingly, the Leon datasets used by Stability to train stable diffusion are not restricted to content from Getty Images websites, but also contain materials scraped from publicly accessible third-party websites and include not safe for work NFSW content and child sexual abuse material CAM content. As a result, stable diffusion is capable of generating artificial image outputs which contain unsafe materials, including the generation of pornographic images. Any association users make between output from Stability's platform and Getty Images therefore risks causing harm to Getty Images' long-standing goodwill and reputation. This is troubling in its own right. The fact that Getty Images trademarks may appear on such images magnifies that concern significantly. Similar allegations appeared in paragraphs 266.3 and 266.4 with a little more detail. the Stability was perhaps a little slow to respond to that, but in an 8th letter from Stability's solicitors to Getty's solicitors of the 6th of June 2025, which was sent at 8:21 p.m. that evening, objection was taken to the paragraphs of the skeleton argument in question. It was that objection that led to the judge making the ruling and order which are under appeal, as I have already indicated in the course of the first day of trial. The judge, understandably, had little opportunity to consider the matter at leisure, and she gave an extempore judgment, having heard argument on it. As the argument was presented by counsel for Stability, the point was a pleading point, namely that allegations concerning CASM were simply not part of Getty's pleading, and specifically paragraph 57.9 of the particulars of claim. The judge accepted that contention for the reasons that she briefly expressed in paragraphs 8 and 14 of her ruling as follows, quote, I do not consider the general wording in paragraph 57.9 of the particulars of claim obviously to incorporate a reference to a criminal act in the form of CSAM. I agree with Mr. Cardigan that there is an obligation on the pleading party properly to plead out its case, particularly where that case involves serious allegations such as fraud or illegal conduct, so that the opposing party understands the nature of the allegations and is able to prepare to meet them at trial. If the claimants wish to rely on the points made in their skeleton argument in this case, they should have applied to amend their pleading to include direct reference to those points. They have made no such application, but have instead sought to introduce this issue on the eve of trial on their skeleton argument. And then at 14, I consider the meaning of the words pornography and, that's in quotes, and violent imagery in quotes to be clear. Without additional explanation, I do not consider the defendant should have appreciated that it was the claimant's intention to include reference to CASM within these terms. In particular, I note that, as Mr. Cardigan points out, the claimants have not sought to rely upon any examples of images in this case, which is said to amount to CSM. None of the images pleaded in paragraph 57.9 of the particular claim fall into that category. Accordingly, I can see no reason why the defendant should have interrogated the terms pornography and violent imagery, much less that he should have understood or suspected that those terms included reference to CSAM. Getty appeals on two grounds. The first ground is that the judge erred in her interpretation of paragraph 57.9 of the particulars of claim. The second ground is the judge erred in her application of the principles on pleading serious allegations. So far as ground one is concerned, Getty contends that the word pornography is not restricted to legal pornography, but on the contrary is broad enough to encompass both legal and illegal pornography, and that child pornography, or CSM, is simply a subset of illegal pornography. So far as ground two is concerned, Getty contends that the judge wrongly applied the rule on pleading fraud or other serious allegations, because in the present case, Getty is not asserting that Stability is itself guilty of or complicit in criminal misconduct or other forms of intentional wrongdoing. Rather, the allegation is that it has built a system which is capable of being misused by users. So far as ground one is concerned, it seems to me that there is force in Getty's criticism of the judge's reasoning. The word pornography is an entirely general word. It is defined in the Oxford English Dictionary, 3rd edition online, as follows, quote, the explicit description or exhibition of sexual subjects or activity in literature, paintings, films, etc., in a manner intended to stimulate erotic rather than aesthetic feelings, printed or visual material containing this. And there is then a statement, a distinction is often made between, quote, hard and, quote, soft pornography on the basis of how explicit or taboo the material in question is held to be. This is followed by a list of illustrative quotations, the last of which is a quotation from the year 2005, as follows. Sentencing has been set for a man who pleaded guilty to downloading child pornography on a work computer. As the definition and the illustrative quotation make clear, the word pornography has a broad meaning. It can be divided into legal and illegal pornography can be further subdivided into various forms. It therefore seems to me that Getty is correct that, taken at face value, paragraph 57.9 of the particulars of claim was broad enough to include what used to be called child pornography and is now more properly referred to as CSAM. That conclusion is reinforced, it seems to me, by a number of matters. Firstly, the fact that the pleading also includes the reference to violent imagery. Secondly, the fact that a number of legal instruments reinforce the conclusion that a subset of pornography is child pornography. I refer, by way of example, to Article 34C of the Convention on the Rights of the Child, Article 3B of the International Labour Organization document, and Article 2 of EU Directive 2011/93. Thirdly, there is the difficulty of differentiating in any clear way between different types of pornography. That, however, is not the end of the matter. I have already referred to the amendment to the particulars of claim that was made as a result of the case management conference on the 30th of April 2025. At that case management conference, counsel appearing for Stability raised the objection that the reference in paragraph 57.9 of the particular claim was very general, and that if Getty intended to rely on specific examples, then Getty should be required to give Stability notice of such examples. He specifically made the point that, as he put it in the course of argument, to the extent that they want to pull rabbits out of hats at trial, I will be saying it should have been there, end quote. The judge expressed sympathy with that point and expressed the view to counsel appearing for Getty that Getty ought to plead the concrete examples which Getty relied upon to show that the assertion was correct. She did not think, however, that it was necessary for Getty to plead the expert evidence that it was relying on. There was then some discussion as to the extent of the examples which Getty ought to be pleading, and the point was made by counsel for Getty that Getty relied upon the examples contained in the exhibit of to the witness statement of Mr. Stanley. The discussion concluded with the following exchange between the judge and counsel appearing for Getty. Quote, Mrs. Justice Joanna Smith, well, the way that litigation should be conducted is that matters on which a party wishes to rely are identified in the pleadings so that the other side knows what case it has to meet. Ms. Lane, exactly. Sorry, I did not mean to interrupt, my lady. That's why we've pleaded that stable diffusion can be used to create images that contain pornography. Mrs. Justice Joanna Smith, I follow that, but I think the defendant is entitled to know if you're relying upon specific examples of images that you say go to that plea, they should be identified. Ms. Lane, fine. We will obviously go away and consider that point, but I do lay a marker down if my learned friend's going to try and put something in response that goes outside the existing plea in terms of a positive case about this. We will just have to wait and see what comes in the amended defence about that, end quote. Thus, as I read the transcript, it was accepted by Getty at that stage that it needed to plead the specific examples that it relied upon in support of the general plea. It was for that reason that the amendment was made, to which I've already referred, to paragraph 57.9, referencing pages 20 and 100 of Annex 8H, as well as the exhibit to the witness statement of Mr. Stanley. It is relevant also to take into account what happened in response to that pleading. First, Stability amended its defence to add a further sub-paragraph to paragraph 100.10 as follows, quote, this is little Roman 3. As to the specific allegations of tarnishment of paragraph 57.9, these allegations are unparticularised with respect to the images relied upon and therefore incapable of response in this pleading. In any event, the claimant's burden is on the claimants to prove the images at pages 20 and 100 of Annex 8H and confidential exhibit DAS 15 were generated through normal or occasional use of stable diffusion and or prompts that are sufficiently likely to be used to justify the relief sought for the reasons set out at paragraphs 74.23, 80 and 96.2 6.2, the defendant will say that these outputs are not reflective of normal use of the models and cannot be attributed to it as use in the course of trade the signs complain of. The defendant will additionally rely on the terms pleaded above in paragraph 61, 63b, 63e, 63f, and 67.4, end quote. The Getty then amended its reply at paragraph 69 to add the following statements. Quote, as to the final three sentences of paragraph 100.10.3, above, the claimants repeat paragraphs 33, 34d, 34g, 34h, 37.5, 44, 43, 48, and 66 above. It's denied that the allegations of tarnishing are unparticularised. However, for the avoidance of doubt, the claimants will contend as follows. 69.1, the images identified in paragraph 57.9 of the POC are not safe for work, having regard to the content of the images, specifically the depiction of nudity and or two, the poses and actions of the persons depicted. 69.2, further, as far as tarnishment of the reputation of the trademarks is concerned, there is a difference between a genuine image of a celebrity or other person who has chosen his or her attire for use in a public performance and or chosen a particular pose of action, and the generation of synthetic images bearing the trademarks that do not depict a real event and or where the person has not chosen his or her attire or the pose stroke action depicted, end quote. The upshot, it seems to me, is that while the original allegation in paragraph 57.9, and specifically the reference to, quote, pornography, unquote, was broad and general, it was understood by the parties at the case management conference on the 30th of April 2025 that Getty needed to particularize these specific images that it was relying upon. It duly did so. The images in question, it is, as I understand it, common ground, are not ones which could be said to be examples of CSAM. On the contrary, they are images, the broad nature of which can be gathered from the reply. That is to say, they are artificial images of celebrities in states of undress. They therefore fall within the broad remit of pornography, but not CSAM. When asked what he contended the purpose and effect of the amendment to the particulars of the claim was, counsel for Getty replied that the purpose and effect of the amendment was merely to ensure that any specific examples of images upon which Getty relied had to be particularized so as not to take Stability by surprise at trial. He contended that that did not mean that the broad scope of the allegation was thereby limited. I do not accept that submission. It seems to me that the purpose and effect of the amendment which Getty agreed to make at the case management conference and did make thereafter was to plead, even if only by way of example, images of the kind objected to. That interpretation is confirmed by the paragraphs of Getty's reply, which I have quoted. those paragraphs make it plain that the objection is to images which are said to be, quote, not safe for work, specifically the depiction of nudity and all the particular poses and actions of the persons depicted. On an objective reading of Getty's statements of case, the allegations that are advanced do not extend to CSAM. Accordingly, it seems to me that the judge's ruling as to the scope of Getty's pleaded case was correct, albeit I reached that conclusion for somewhat different reasons to those given by the judge. I would therefore dismiss this appeal.
I agree that the appeal must be dismissed for the reasons given by Lord Justice Arnold. Pornography is a very wide term, which, as a matter of ordinary language, is capable of and does include child sexual abuse material, and also what is referred to as extreme pornography. Possession of both of those categories of pornography is illegal. Even pornography which it is illegal to possess covers a wide range of images, as can be seen, for example, from the guidelines given by the Sentencing Council in relation to what in that context are called indecent images of children, which distinguish between, for example, images which show penetrative sexual activity, other sexual activity, and other indecency. Accordingly, the reference to pornography cried out for particularization, and that was the purpose and effect of the discussion which took place at the CMC on the 30th of April, to which my Lord has referred. The examples which were then given were artificially generated images purporting to be a celebrity performing topless or naked. The purpose of those examples was to clarify the case which the claimants were making. Mr. Block expressly accepted in the course of his submissions this morning that there could be a plea in general terms, of which particulars were then given by way of example, which would narrow the scope of the pleading, although he went on to submit that that was not the purpose or effect of the amendment which followed the April CMC. In my judgment, that was precisely its effect. I would not want, however, to try to define too precisely the precise limits of what is covered by the pleading as it now stands. It is sufficient to say that the examples given are very far away from pleading a case which includes reliance on child sexual abuse material or other material which it is illegal to possess. It is notable that at no stage of the case were directions given for handling child sexual abuse material, which directions would have been necessary if that had been understood to be an element of the case which the claimants were advancing. That may not be strictly relevant, as the question of interpretation of the pleadings is an objective rather than a subjective question, but it goes some way to explain why the judge was right to be surprised by the allegations relating to child sexual abuse material, which appeared for the first time in the claimant's skeleton argument for trial. I would mention one further point, which is concerned with the terms of the judge's order. Paragraph 1 of her order reads that, quote, the allegations are not pleaded in paragraph 57.9 of the claimant's amended particulars of claim, close quote. The allegations with a capital A is a defined term referring to the allegations advanced at paragraphs 5, 266.3 and 266.4 of the claimant's trial skeleton. Paragraph 2 of the order reads, quote, accordingly, the allegations, with a capital A, may not be deployed as part of the claimant's case at trial, close quote. Mr. Block developed or began to develop a submission that even if we were against him in his appeal from paragraph 1 of the order, that is to say, if we concluded, as we now have, that the allegations relating to child sexual abuse material are not pleaded, it should nevertheless be possible for the claimants to deploy the allegations, capital A, as part of their case at trial. However, as was pointed out in the course of argument, there is no ground of appeal to suggest that that is a separate point, nor was the point developed in the claimant's skeleton argument for this appeal, and in the event, perhaps because counsel appearing before us are not, or at least Mr. Block is not trial counsel in the ongoing trial, it was difficult to know what real significance that point has. But as it is, we will simply dismiss the appeal from the judge's order. I'm glad that we have been able to hear this appeal without there being too much disruption to the trial. The Court of Appeal will always do what it can to hear cases of genuine urgency at short notice. In this case, the claimant's appellant's notice is dated the 12th of June 2025, that is to say last Thursday, and the appeal has been heard and judgment has now been given within only 2 working days. Are there any further applications?
My Lord, I would presume that we will seek our costs of the appeal, but we perhaps can deal with that in the usual way in relation to a draft order and mixed submissions in that way. But,
well, surely we can
Well,
deal with the
can't we do it?
principle.
I think we
Can
could
we
deal
do
with
now?
the incidence of costs. Yes, we seek our costs on a standard basis.
I can't oppose that, my
No.
lord.
All right. Well, let's we'll make that order. Thank you all very much, and thank you very much to the teams behind you who've obviously worked very hard to prepare all the material. I referred slightly tongue-in-cheek to 2 working days. I appreciate for all of you it's probably been twice that.